Good afternoon, everyone. You're welcome on JustEventOnline TV. I'm Abdulkadir once again on the program Issues and Reality. Today I have with me Madam Taofeeq or Olareju, the immediate past General Secretary of Kwara State Chapter of the Nigerian Bar Association (NBA), who will be taking us through the journey of Kwara State and Kwara government on the 2025 Kwara State FOI bill. I think it's still a bill because I don't think the government signed it into an act. But I think from our own point of view here, the news we have is that it has passed all the legislative processes, and the only thing that is needed now is the transition from the House to the governor, who will give his final assent. But before we go into that, let's do a rundown of the history of FOI bill in Nigeria. The FOI bill is an act that was signed into law by the administration of President Abdulkadir Jonathan, which was meant to give unfiltered access to the citizens of Nigeria to government information, spendings, policies, and statistics. So that is, people have all the right to go to government to say that we need this information, as long as these informations are not injurious. I think the word injury and all those things will be defined by legal luminary in the house. But after that, there have been a lot of things. Some states have said that, okay, we are fine, the FOIB is operational in our state. Some states have said, no, we need to domesticate. I think I've seen a case in Lagos State. Personally, I've read a case of FOIB being operational in Lagos State, where people get information with the national FOIB. They don't have to go through the domestication palaver. But the question of FOIB in Kwara State really started in 2019, when the 8th Assembly, led by Right Honorable Professor Ali Ahmed, passed the bill to the governor then. But the governor then was supposed to be Governor Fattah Ahmed. But after the rigmarole and the legal processes, it fell on the desk of Governor Abdulkadir, who made some little changes. I think just 2 changes were made to the bill, and he passed it back to the House in 2019. But now, in 2025, the shocker was that a new FOI bill resurfaced from the governor himself again. One has gone before, another one is now again. Now, the question remains, the federal, or we like call it the national FOI bill, contains 32 clauses or sections, but this Kwara State FOI bill contains 33, which brings about the controversial section 31 of the law that says that the governor must give a consent in writing to any request for information from any MDA, which everybody has said, NSU that says it's obnoxious. The PDP said it is corruption enabling, and the MBA, the Kwara MBA, said no, we don't agree with this. And I was at the hearing on that day. There was no single private person that agreed with this section 31. The only people that agreed with this section 31 were the government parastatal, namely the Ministry of Communication, the Ministry of Justice, the SSG office, the Office of the Head of Service, ERAD, Kwara State Broadcasting Corporation. Every other person or body present on that, they said no to this law, except the TUC. The TUC had no issue with Section 31, but they had an issue with the word injury that earlier mentioned, that the word injurious information should be defined so that the people, their workers, their members will not get caught in the problem of shouldn't you know what is injurious. But the NUJ, the NLC, the MBA, the PDP, the NSU, and every other person that spoke on that, he said they admonished the Kwara State House of Assembly to have a second look at this section 31. But anyways, it has been passed anyway, and here we are. I think the legal luminary here will tell us what the implication is, because there was a statement made by the representative of the MBA on that day about the principle of covering the field. I don't know what that means, but he will tell us what that means in the course of the program, and other things. Somebody talk about the Supreme Court judgment that could be affected. You're welcome on the show, sir.
Thank you so much.
I think I've done a lot of talking.
Thank you for having me once again. Thank you so much. I really appreciate it.
All right, sir. Therefore, the Kwara State FOI 2025. I want to start with the Kwara State FOI 2019 that was passed by the House led by Professor Ali Ahmed, but it was transited to the governor, and then the governor sent it back to the 9th Assembly. The 9th Assembly left it lingering for 5 years, and for 6 years. And a new administration, the same administration, the same House leadership has gotten another FOI. But shouldn't you think, in a serious line, shouldn't there be a question of, we have a lingering one? Let us look at that. Why do we need a new one? Because the question, the doubt, I want to talk about the doubt everybody has, is that recently there was a judgment of the Supreme Court that says that the FOI bill is operational. I think you were here on this program, and we discussed that. You said that the FOI bill is operational. There were a lot of people that disagree with you. I don't know if you were here. We are aware of that. A lot of people disagree with you in some platforms in Kwara. But the next day, that is Wednesday, the program was on Tuesday. The next day, a judgment came out, and it favored what you said. And the funniest part is that some people are saying it is the judgment of that judgment of the Supreme Court that informed the political decision of this current administration to write their own FOI bill, but in contradiction to what the parent bill, that is the national FOI bill, has. So please, can you please bring up to say, the first thing is, when the bill came in, shouldn't the House of Assembly have asked a question of, we have one already, why are you sending a new one?
Before I go to answering your question, let me quickly trace the historical background of the freedom of information, and that could be traced quickly to the United Nations Declaration of Human Rights, Article 19, 1948.
Wow.
Since 1948, we are in 2025.
Almost 100 years.
We are still struggling to have freedom of information. You see the problem here now. The extent is a treaty of the United States that the Nigerian government is signatory to. And the
United Nations?
Yes, United Nations. And the Nigerian government is a treaty that we are signatory to.
Wow.
So operationally, that treaty is operational in Nigeria. That is why we are signatory to it. And you see that it started in 2011, as you rightly mentioned. And in 2011, Nigeria was the 9th African country that will make that law a reality. And 90 in the whole of the world to make it a reality. But since 2011 to date, we are still where we are in Kwara State. And if you look at the imports, the major import of that bill, if it becomes law in Nigeria, in Kwara, is nothing but transparency and accountability. And if you see how people run government in this country, Kwara State inclusive, they do it in more of secrecy than openness. And at the end of every, at the time of every election year, they will now come to the people and cajole them to bank on their trust. So there is problem of distrust between the people and the government because of this type of situation. Now, in 2011, when that bill was passed, we have a working, and let me say, able state assembly here in Kwara by the then members and the leader, the chairman, and the speaker of the Kwara State Assembly. They did not deem it wise or thought it wise to domesticate that bill.
Since 2011.
Since 2011, not until wee hour after they are about packing their loads to leave government, that bill was passed within 24 days in 2019. Now, the information we had was that the government, the governor, the present governor of Kwara State, did some amendment and forwarded the bill back to the State Assembly for them to do the needful. They kept the bill there for reasons best known to them, not until the judgment that I said. Well, you see, in Nigeria, let me say, in legal parlance, you don't need to create unnecessary problem when there is none. The act of FOI Act is an act of the National Assembly, and the Act of National Assembly is applicable everywhere in Nigeria, except if you are telling me that the place you are talking about is not Nigeria. Let me give you an example. We have the Evidence Act 2011. It's an act of the National Assembly. It's applicable in our courts in the Ilorin, Kwara State without any domestication. So now, that was what I said the other time, that we have the Supreme Court cannot overrule themselves in this present instance. They've said it time without number that an act of the National Assembly is applicable in the whole of the Federation. That is the law. That is the law. Now, to now come to your question. Well, me too, I asked myself that question severally. That when we have a pending bill, all what we just need to look at is that where do we need some things that might have not been catered for by the act itself, and it will be beneficial to our people or the operators of the law in our own state here. That is the only reasonable man thought as opposed to come to our mind. Not holistically changing or redrafting our own another one. To my mind, that will amount to what we call legislative wastage, because that will not go unfunded. One or two things financially, we bear the consequence. And look, mind you, this is a country and a state that will continue to clamor that our source of income is so meager, and will continue to waste resources like that. One would think of it. I mean, too, I thought of it, and I'm of the view that what is needed to be done is to work on the existing one, bring in some alterations as the need be, in line with the act.
Yes.
That is the FOI Act. Yes. So that will make it work for all and sundry in the state. But to my mind, the reverse was the case. There was a different, according to what we had in the media, there was another draft of the whole bill. But going through it, you will not pick offense from any of the provisions except that section 31 that gives the governor the unfettered power to release or withhold any information that any of the general public may intend to make inquiries. And you now ask yourself, by that section 31, is the whole bill, has the whole bill not been defeated? The answer is yes. Because what is the essence of that bill initially? The essence of the bill is transparency, accountability. It is obvious that successive government, civilian government we have in this country, has been proven to be reckless in governance, financial management, office management, and a lot of others. So this bill is one of the ways that public office holders can be checked. And don't forget that as a human being, if you notice or you know very well that some people are watching your back, you will sit upright and you will do what is needful. And you will do what you want people to meet you there and give you kudos. Not the other way around. So as I'm talking to you here now, you see that all our 24 hours of assembly members, none of them was against the expunge of that disastrous section 31 of that act. I call it disastrous because if you look at the whole body, if a part of the body is affected with cancer, that part becomes cancerous, becomes disastrous if it's not properly or immediately eliminated from the whole system. So that section is inimical to the aim and objective of the initiator. United Nations, don't forget that United Nations Declaration,
like said in 1948.
1948, Article 19, is against that treaty that Nigeria was signatory to. It's against the Act of the National Assembly. And the position of the law is very clear. Any law that is inconsistent with the provision of the Constitution of the Federal Republic of Nigeria 1999 as altered, that law will be rendered inconsistent, will be rendered null and void to the extent of its inconsistency. So practically now, that law cannot stand with the Constitution of the Federal Republic of Nigeria.
Are you saying that
that law cannot stand shoulder with shoulder with the FOI Act? So that law, as we speak, is not in existence in legal balance. Because if you already know the outcome of a decision, why now making that decision with respect to provision of the law? Because the law cannot be operating in isolation, cannot be operative in isolation.
So, but my question is, who do we blame in all of this? The governor wrote it. The governor is one person. Let's say he has his cabinet, but he passed this through 24 state members, state assembly members. Who do we blame in all of this? There was a man that spoke on that. I don't want to mention name. He said he was there for a moral talk, and he said the fact that the governor cannot write this law in his bedroom and sign it himself means that you guys have a leverage. But one way or the other, they passed it anyway, which means it has been passed by people that were elected to be in charge of our legislative processes. Do we blame the governor for this or the House of Assembly?
We cannot blame the governor. The governor, by law, can originate an executive bill, which to my mind, that is what he did in this instance. Now, don't forget that democracy has three arms. And these three arms, they are independent of one another. And what we are saying is that these three arms, they have their different independent functions for us to have good governance. If the governor, as the chief executive officer of Kwara State, presented an executive bill, he can make it an executive order if he so wish. But he presented it as a bill to the state assembly. You know the answer. The answer is that the state assembly, the 24 assembly members, do they got our mandate before they make the allusion they make to that bill? The answer is no.
No, sir. There's an impression I would like to make there in where you stood. On that day, I was a party to the public hearing. There was a public hearing. And I think it is meant for the legislature to feel the pulse of the people about a certain law. public hearings are meant to fill the pulse of the average voters about a whole law or a section of the law. And I can tell you for free, I've seen news coming around that everybody else, the government board, I will tell you that there were people there, there were bodies there. The NUJ, NLC, NETSUD, the NBA, I know, if you're not privy to any, you'll be privy to it. And then the main opposition party in the states, the PDP, and the general public. A lot of people talked on that day, except the people that came from the side of government. And I mean, the people that came from the side of government are the Commissioner for Communication, the representative of the Ministry of Justice, the representative of the Office of the Head of Service, representative of the Office of SSG, the Kwara State Broadcasting Corporation, and Iran newspaper. All went for the bill and with no objections. But all these people that I mentioned, except everybody that were there, except the TUC, everybody made an objection to this same act. Like, what I want to say is that do the House have the mandate to act against the will of the public? Because the public was there, and the pulse of the public says we don't want this thing. Like, when we talk about democracy, we talked about democracy. Does the House has the power to act against the will of the people? They call themselves to a public hearing.
You see, public hearing is part of lawmaking process, because if you look at the definition of democracy, we call it government of the people, by the people, and for the people. So if you are making any law for the people, they should, by law, have impact, have input in that law, and that is the essence of the public hearing. So now, public hearing, what they just want to know is that they want to have the feeler of the law from the public perspective. What are the public saying about this bill that may later metamorphosize to being a law of the state? Because laws are made for people. People are not made for law. That is the law. Now, but what we have in our own democracy today is upside down, in the sense that the state assembly, they still, despite the outcry and demonstration of the cancerous provision, so that's Section 31, by the general public, the state assembly, they still go ahead to pass the bill. That means that the input of the people, the input of pressure group, the input of experts were not put into consideration before taking that deadly decision. And the implication is that that law will be operative immediately the governor assents to it, and nobody can do anything except if you challenge it in a court of law.
Okay, now let's go to the challenging. I think the representative of the NBA on that day said that this law is a waste of time if it goes with section this. You said
that's section 31. Yes,
31. That the government, the apex court will never override itself. They will always stand with what they've said. That if there's an inconsistency with the domesticated law, we'll go with the parent law. Do you think? And I mean, NETSUD has threatened to go to court. Like, you gave a legal position the last time, and the apex court aligned with you. I want you to give another legal position. Are you saying that this law, if it goes all the way to the apex court, like, are you saying we'll win it?
It cannot even stand the test of time. I said it earlier that that law, you see, I'm a lawyer, right? And I'm talking as one. That law cannot witness the light of the day, because people will challenge it. And let me tell you something. What this present administration, they know what they are doing. They are just playing politics around the corner. Their intention is to withhold some secret, and by implication, they don't want to be transparent to the people that put them in office. That is the literal meaning of what transpired on this bill from day one to present till now. If you look at the past administration, the PDP-led administration, they did not take any step since the time they have been in power. Not until we are leaving office, they rush to do it. So what their senior House of Assembly members taught them is what they are now exhibiting now.
Are you saying that there's no difference between this one and the one that came before them?
Virtually, but on this bill, there is nothing. There is no difference. There is none. Because if you look at it, what those people did was that we don't want to be giving you information, and we know that if you ask of information, there's an act of Nigerian Official Secret Act that prohibits public office holders to divulge government official secret to the public. So we are going to deal with you with that. And Section 91 of the Evidence Act 2011 also prohibits you from giving out some certain information with respect to government within the confines of the government, information within the confines of the government. That section prohibits you to give it out. But this law now is not telling you that you and I, not only government, that is where we are making mistake. Not only government, our institutions. Every public office we have in the state, they should be accountable to us. I mention our institution because they should give us account on what are the quota system, what are the modules, what are the procedure they adopted in giving admission.
Okay.
It's part of what this bill can allow you to assess. Even the University of Ilorin, by this bill, you can challenge them. And by this bill, by this law, they are responsible to give you an accurate answer. If they fail to do so, you take legal action against them, and it will be detrimental to them. You get it? So, but if if the act is trying to expose us to having a good democratic practice, and the state law is trying to be retroactive in this regard, just because the state House of Assembly members, because of one interest or the other best known to them, they refuse to do the needful. Now the question is that there is problem. You know who has had with responsibility of making the necessary adjustments when it comes to issue of making laws, and they fail to discharge that responsibility. Don't forget that these people, they sworn to different oath of allegiance and oath of office, and part of what they said was that they will not allow their personal interest to influence their official decision. They sworn, and what I quoted now is part of the phrases that I'm sure that they sworn to. Now, because of one interest or the other, now that I may not know, you may not know.
Exactly.
Now they're
subverting the interest of the public.
So you see where the problem is. So now, if we are saying that the previous administration, they did not practice democracy the way it ought to be practiced, which brought about the Otoge movement, that look, we want changes. Things cannot continue to be done the same way. So we need liberation and development. And the people of Kwara trusted power to them. And this is what they used to pay back the people of Kwara. Honestly speaking, I personally am disappointed.
All right, sir. I think to cap this thing up, to do a final, to be on the final note, like, where do we go from here? When the people come together to say, okay, we want to change government, and it's as if that the people or the politicians are or twins of different fathers. We just change faces, and we still see almost the same thing. Where do people go from that? Like,
you see, the problem is that is why I mentioned the issue of trust. You see, nobody that want to hijack government through political process will come and tell you that if you elect me as so and so, I'm going to deal with you. Nobody will do that. Even military administrators, they will not do that. It is when they are empowered that they will now continue to show us shaky pro max, like what we are witnessing now. Now, that takes us to the issue of trust. People don't trust the system again, and that leads to voters' apathy. People don't have interest in voting, save for passing exams. People don't even want to know what is the name of the commissioner, what is the name of their commissioners, what is the name of any public officer. They don't even want to know it, because they know what is the essence of knowing them. The responsibility that they are saddled to do, that they undertook that if we get to this place, this is what we are going to do. They will even do it more worse than the people that they hijack government from. So what are we saying? So what they are telling the people is that you are taking us for right. Because if we can trust you that look, between Mr. A and Mr. B, Mr. A has been tested. We are not going to trust him again. But this Mr. B, with what they are telling us, definitely, let us give them a chance. And you fucked up. So look at, people will now continue, people will now start to lose trust in government. And by extension, patriotism will drop. And that is what is happening to us as a nation now.
okay.
People don't respect the Nigerian flag, the coat of arms, the national anthem anymore. Talk more of respecting of public office holders. We've seen situations whereby public office holders are being attacked physically, abused, molested. And at the end of the day, do that one give us the needed result? No. So people just believe that, look, instead of me wasting my time, kill you under the sun, under the rain, to go and vote, because if we vote for a set of people, they will not give us the exactitude of the needed good governance. So why wasting my time? And if you look at what government, what the National Assembly intends to do now, they intend to criminalize your willingness. If you fail to vote, they want to criminalize. If that bill is by the National Assembly is passed to an act, it becomes an act of the National Assembly now. So if you fail to vote, to go out on election day to go and vote, it will be a criminal offense. If you are found wanting,
I think we rely on you lawyers to let us know whether that goes in line with the freedom of association.
That is against the freedom of association, and is against even the Constitution. That the Constitution said by you can associate and dissociate, and so and the Act of National Assembly I want to compel you to go and associate by all means. So it's against the Constitution, and that bill also cannot stand.
All right, I think that's a very good place to leave it. I think some other time when we have legal to too, and we'll bring you to the studio. I think thank you for. But I want to ask this last one before we go. There was when we asked somebody asked a question about the act being there since 2019, and then a new one being imported, and the response from the House is that they cannot act on a bill that was not processed by them. It has to start from the first reading again since they did not pass it. I want to know if that is tenable. Like, if that is a tenable excuse.
Well, as far as I'm concerned, if there is a serious amendment to the bill by the executive governor of Kwara State, I think it will pass through the process of lawmaking again. But if the amendment is not a serious one, there is nothing stopping the governor from assenting. But if it's a serious amendment, fundamental amendments, it will pass through the process of law. That is the law.
All right, thank you very much, viewers. That's a very good place to leave it. I remember some of the countries they once again. Thank you very much, sir.
Thank you for
That's been a very lengthy and educating one. Thank you very much.
Thank you for
have a
having
lovely
me.
day.
Thank you for having me.